I grew up in a house where love was distributed like limited edition coupons, only so many per household, and my brother always had more. My mother ran that system with a kind of cheerful efficiency that made you question whether it was intentional or just how she was wired. Either way, the math never changed. Daniel got the praise. I got the bar raised. He was 4 years older, and from the time I could understand what attention meant, I understood that his brand of it came easy. He was loud in the charming way, the kind of person who walked into a room and made it brighter without trying. Teachers loved him. Neighbors stopped to chat with him on the driveway. My father used to say Daniel had a gift for people, like it was a rare talent worth protecting. Meanwhile, I was in my room with a calculator and a library book, apparently ungifted. When I got into college on a full academic scholarship, my mother told her book club I was very focused. Daniel had gotten into community college 2 years earlier, and she had cried at dinner from pure joy. That was the kind of math I grew up with. I didn't resent him, exactly. You can't resent sunshine for being warm. But I noticed everything, and I filed it all somewhere quiet inside me, the way people do when they learn early that nobody's listening anyway. I became a compliance officer at a federally chartered bank, BSA, anti-money laundering, financial fraud detection. People's eyes glazed over when I explained what I did at parties, which suited me fine. My job was to notice what other people missed, to find the irregularity buried in 10,000 transactions, to follow the paper trail until it led somewhere that couldn't be explained. I was very good at it. My director once told me I had an instinct for patterns that most people spent 15 years developing. I didn't tell him I'd been practicing since childhood. My father passed away 11 months ago. It was sudden, a heart attack at 63, sitting in his armchair watching baseball. He hadn't been sick. There was no slow goodbye, no chance to say the things that had been waiting on the edge of sentences for years. One evening he was alive, and the next morning he wasn't, and the whole world rearranged itself without asking anyone's permission. He left a house in Lexington, Kentucky, where I grew up, and a savings account with $182,000. His will was clear, split equally between Daniel and me. My brother was named executor. I didn't question it at the time. Daniel and I weren't close, but we weren't enemies. And I trusted my father's paperwork the way I trusted most paperwork until I had reason not to. The reason came 6 months after the funeral at a Saturday lunch at my mother's house. She'd been selling it on the idea that it would be good for us, all of us together, her and Daniel and his girlfriend and me, good food and catching up. She said it like there was a lot to catch up on. I drove the 4 hours from Cincinnati because my father had just died, and sometimes you do things for the living even when the dead are why you came. Daniel was already there when I arrived, leaning against the kitchen counter with a bottle of beer, wearing the kind of easy smile that meant he'd been there long enough to get comfortable. He gave me a hug that lasted exactly as long as it needed to look sincere, and pulled back. "There she is," he said, "the big city banker." I said it was good to see him. I meant it about 60%. Lunch went the way these things go. My mother told a story about Daniel fixing her gutters. Daniel told a story about a deal he was closing on his landscaping business. His girlfriend laughed at everything he said, which was either love or conditioning, and I couldn't tell from where I was sitting. I talked about work briefly, and my mother nodded the way she did when she was waiting for a pause to redirect to something she actually wanted to discuss. At one point she said, "You know Daniel's been handling everything with the estate. He's been such a help." I said I knew, and that I'd actually been meaning to get copies of the finalized documents. The title transfer on the house, the probate paperwork, the account statements. Daniel's smile didn't change, but something behind it shifted, just a flicker. I'd seen that in audit interviews before, the moment someone realizes you're not asking politely, you're asking professionally. "It's mostly still being processed," he said. 6 months felt like a long time for processing, I said. "Still friendly. Still even." My mother waved her hand. "Oh, these things take forever. The lawyers drag everything out. Daniel's been dealing with it all. You should be grateful." I said I was. But I wasn't. Really. Because I'd spent the car ride down already drafting the request in my head, what documents I'd need, what signatures should appear where, what a clean estate closure looked like, versus one that had been managed loosely. By the time dessert was on the table, I'd already decided to pull the property records myself when I got back to Cincinnati. I didn't have to wait that long. 3 days later, sitting at my desk on a Tuesday morning, I ran the Fayette County property records online. It took about 4 minutes. The house had been transferred by quitclaim deed 2 months after my father's death. The deed listed a single grantee, Daniel's name only. Below the grantor's signature line, there were 2 names. My father's, signed before his death as part of what appeared to be a pre-signed instrument, and mine. I stared at that second signature for a long time. My name, in handwriting that looked close enough to fool someone who wasn't looking carefully. But I was always looking carefully. The loop on the Y was wrong. The spacing between the letters was off. I had signed thousands of documents in my professional life, and I knew exactly what my signature looked like, the same way you know your own face in a mirror. I hadn't signed that deed. I went very still the way I always did when a pattern clicked into place. In compliance work, the moment you identify fraud isn't loud. It's quiet, your heartbeat doesn't change. Your hands don't shake, you just start documenting. I printed the deed. I pulled the savings account records I'd requested from the probate attorney weeks earlier and never received. I called the attorney's office directly and asked for the account transfer documentation. There was a pause on the line before the assistant said she'd need to check on that. That pause told me plenty. Over the next 2 weeks, I gathered everything I could through legitimate channels, county clerk records, the probate court docket, correspondence from the estate attorney's office. I contacted a private forensic document examiner I'd worked with through the bank. He charged by the hour and didn't ask unnecessary questions. When he sent back his preliminary analysis of the signature on the quitclaim deed, the conclusion was 4 words in the executive summary. Not consistent with original. I drove back to Lexington on a Friday evening not because I wanted to, but because this was the kind of conversation that had to happen in person. I'd learned that in my job certain disclosures you deliver face to face, because you need to see the response with your own eyes. My mother was in the living room. Daniel was in the kitchen. I sat down at the dining table and put the deed on the surface in front of me, along with the document examiner's report. "Daniel," I said, "can you come in here for a minute?" My mother sensed the temperature immediately. She sat up straighter, folding her hands in her lap the way she did when she was preparing to manage something. "What is this?" she asked when she saw the papers. I told her. Clean and factual. The deed, the signature that wasn't mine, the missing savings account documentation, the forensic analysis. Daniel stood very still on the other side of the table. My mother looked at him first, then at me, then back at him. "There must be some misunderstanding," she said. Her voice was composed, almost automatic, like a script she hadn't needed in years but still remembered. I said there wasn't. Daniel exhaled. He did this thing with his jaw, a tightening that I'd seen before, usually right before he said something he knew would land badly. "You always have to make everything into an investigation," he said. "You can't just be family. You have to be the compliance officer at every single—" "I'm not making it into anything," I said. "You forged my signature on a legal document. That's a felony." The word landed. My mother stood up. Her hands dropped to her sides. She said, "Maya." "Not his name. Mine. Like I was the one who had done something." Daniel moved around the table faster than I expected. He grabbed my arm above the elbow, fingers closing hard, and said, "You are not going to do this to our family." His voice was low and pressurized, like something that had been building since I walked in. I told him to let go. He didn't. He pulled me sideways, and when I twisted to free my arm, my hip caught the corner of the table, and I went down hard onto the kitchen floor. My palm hit the tile to catch myself, and the impact ran all the way up to my shoulder. For a second I stayed there, processing, not from shock, from training. Assess first, react after. My mother said. She grabbed him first. I was still on the floor. I had not grabbed him first. She said, "You provoked this. You come in here throwing around accusations." Daniel took a step back, hands up now, like he was the one who'd been attacked. He said, "I barely touched her. She's making it into something. You see how she is." I got up slowly. My hip was already aching in a deep, spreading way. My palm had a red mark from the tile. I looked at my mother, who was looking at Daniel, and I understood with the complete clarity of someone who had finally run out of alternate explanations that this was not going to change. This was the system I'd grown up in, and it was still running. I picked up my purse off the chair where I'd set it. I picked up the deed and the forensic report. I said, "I'm going to need you both to understand that this is no longer a family matter." My mother said, "Don't you dare." I walked out. In my car, I sat for 2 minutes. My hands were steady. My shoulder ached. I took photographs of my palm and my hip before driving away, because that's what you do when you know evidence has a shelf life. I called my firm's outside legal counsel on the drive back. He was a real estate and white-collar attorney who I'd worked with on 2 previous fraud referrals. It was after 7 on a Friday, and he picked up on the third ring. I told him what I had: the forged deed, the missing savings documentation, the forensic analysis, the assault. He was quiet for a moment, then he said, "Maya, you know what you've got here." I said I did. He said, "Then let's do this correctly." Monday morning, I filed a formal complaint with the Fayette County Commonwealth's Attorney's Office. Forgery of a legal instrument, first degree, under Kentucky statute. I attached the deed, the forensic examiner's report, and a signed affidavit. The same day, my attorney filed a civil complaint in probate court to freeze the estate assets pending investigation. I also filed a police report for the assault. Simple assault, documented, with photographs. I didn't call my mother. I didn't call Daniel. I sent a single email to both of them, copied to my attorney, stating that all future communications should be directed to counsel. My mother called me 11 times over the following week. I let them all go to voicemail. When I finally listened, her messages started as confusion, moved through hurt, and landed somewhere around tactical. The last one said, "Daniel has an explanation for all of this, and I think if you'd just sit down with him and listen, we could handle this in the family. You're going to destroy everything your father built. Is that what you want?" My father built a house and a savings account that were supposed to go to both his children. That wasn't what Daniel had built. Those were different constructions entirely. The investigation moved methodically. The Commonwealth's Attorney's Office requested the original deed from the county clerk, subpoenaed the estate attorney's records, and obtained the savings account transfer documentation directly from the bank. That last piece confirmed what I'd already suspected: Daniel had used a power of attorney that had technically expired at my father's death to transfer $78,000 into a personal account, then used the remaining balance to fund a business expansion he'd announced to his landscaping clients 3 months after the funeral. My attorney called me with the account records summary and said, simply, "It's worse than the property." I said, "I know." The estate attorney cooperated immediately and completely. He hadn't known the POA had lapsed, he said. He hadn't independently verified the signatures on the quitclaim deed. He had trusted the executor. He was very sorry. Sorry didn't move money, but it added to the documentation. Daniel hired a local attorney, a man named Gary Webb, who did a lot of real estate closings and apparently also handled whatever walked in the door on a Tuesday. My attorney described him as earnest. I described him as outmatched. 3 weeks after I filed, Gary Webb sent a letter to my attorney offering a settlement. Daniel would agree to a 50% split of the remaining estate assets, whatever was left after the business withdrawals, if I agreed to drop all criminal complaints and sign a mutual non-disparagement agreement. My attorney read it aloud to me over the phone. I said no. He said he'd expected that. The forgery hearing was set for the first week of November. Assault was scheduled a week later, same courthouse, different court. I took the week off work, which my director approved without asking why, just saying, "Take whatever you need." I drove to Lexington the night before and checked into a hotel near the courthouse. I didn't stay at my mother's house. I didn't drive past the old house. I ordered room service and reviewed my documentation one more time, not because I needed to, but because reviewing documentation settled me the way other people used meditation or warm baths. This was my version of calm. The morning of the hearing, I wore a navy blazer and flat shoes and pulled my hair back. My attorney met me outside the courthouse at 8:30, briefcase in hand, looking like someone who had done this exact thing many times and found it neither exciting nor stressful. "It's clean," he said, meaning our case. It was a compliment and a summary at once. Inside, the courtroom had that particular institutional smell of carpet cleaner and old paper. My mother and Daniel were already seated at the respondent's table. Daniel was in a suit that didn't quite fit across the shoulders. My mother sat with her purse in her lap, and when she saw me walk in, her jaw tightened in a way I recognized as the suppression of something she'd decided not to say. Yet, Gary Webb leaned toward Daniel and whispered something. Daniel nodded without looking at me. The judge was a woman in her 60s, silver-haired, glasses, the sort of expression that conveyed she had exactly zero patience for anything that wasn't directly relevant to the case in front of her. She looked at the filings for a long moment before she looked up. Gary Webb went first. He presented the argument I'd expected: a grieving family, a clerical misunderstanding, a brother who had been handling a difficult estate alone while his sister lived out of state and left all the work to him. He said Daniel had intended to have the proper documentation completed and had proceeded in a way that was, admittedly, procedurally imperfect, but not criminal in intent. The judge did not nod along. She made notes. My attorney stood up and placed 3 documents on the bench: the certified forensic report, the subpoenaed bank records, and a notarized statement from the estate attorney acknowledging that no valid POA existed at the time of the account transfer. He said, "The record is unambiguous. A legal document was executed using a forged signature. Estate funds were transferred using an expired legal instrument. Both actions are independently chargeable under Kentucky statute, and both are independently documented beyond any evidentiary standard this court requires." He sat down. The judge looked at the documents. She turned to Gary Webb. "Counsel," she said, "your client's signature appears on the deed as the named grantee. He executed the property transfer. Can you explain the mechanism by which he believed this was legally authorized?" Gary Webb said, "It was the understanding that—" The judge said, "Not the understanding. The mechanism." He paused. He opened a folder, closed it. He said that his client had relied on the estate attorney's guidance. "The estate attorney," she said, "has filed a sworn statement that he did not provide that guidance and was unaware the POA had lapsed." The room was very quiet. Daniel stared at the table in front of him. My mother looked at her hands. The judge set down her pen. "Mr. Webb," she said, "I want to be direct with you. What I have in front of me is a forensic determination that a signature was fabricated, a financial transfer made under a legally void instrument, and an estate attorney who says he was misled about the authorization. That is not a clerical misunderstanding. That is a pattern." Gary Webb said something about good faith reliance and family complexity and the emotional weight of grief. The judge said, "I'm sure it was difficult." She didn't sound like she was offering comfort. She sounded like she was acknowledging a fact before setting it aside. She turned to face the courtroom directly. "This court finds sufficient basis to refer the forgery complaint to the Fayette County Grand Jury for formal indictment proceedings," she said. "Additionally, the civil freeze on estate assets will remain in effect pending criminal resolution. The estate attorney of record is directed to cooperate fully with the Commonwealth's attorney's investigation. Mr. Webb, your client is ordered to have no contact with the complainant, direct or indirect, pending final resolution of both this matter and the related assault complaint." She looked at her files one more time. "I'll also note for the record," she said, "that the integrity of estate administration depends on executors acting in good faith. When that fails, the system has to catch it. In this case, it did." Daniel's chair scraped back slightly. He wasn't standing, just shifting, the way people do when their body wants to escape what their mind hasn't accepted yet. Gary Webb leaned toward him immediately. My mother touched Daniel's sleeve, and he pulled away from her the way Lauren had pulled away in that other story, in that other courtroom, the same gesture, the same realization that the people next to you can't actually absorb the consequences for you. My attorney gathered his files quietly. He didn't look triumphant. Neither did I. We walked out into the hallway, and he said, "The grand jury referral is strong. They'll indict." I said I knew. He said, "The assault hearing next week should go similarly. You have the photos, the ER documentation from when you went in that night, and the timeline of the conversation." I'd driven straight to urgent care after leaving the house that evening. I had imaging for the hip bruise, photographs, a nurse's intake notes. I had done all of this calmly, because I'd known from the moment I hit the floor that I wasn't going to need emotion to tell this story. I was going to need records. My mother found me in the hallway before I could reach the exit. She came around the corner quickly, like she'd been watching for me. There was no performance left in her face now, just something raw and tired and slightly accusatory, the expression of someone who has spent her whole life managing people and has just discovered that one of them stopped being manageable. "You really went through with it," she said. I looked at her. I didn't feel the need to explain. The documents had explained everything. She said, "Your father would be heartbroken." I thought about my father, his handwriting on the will, the care he'd taken to make sure both of us were provided for, the trust he'd placed in Daniel as executor, in the belief that his son would honor it. "Dad would be heartbroken about the right things," I said quietly. "Not about this." She shook her head. She said something about family and forgiveness and what people would think. The old arguments, worn smooth from years of use. I said, "I hope you take care of yourself," and I meant it. Then I walked past her and through the courthouse doors. Outside, the November air was cold and clean. My attorney was typing something on his phone. Down the block, two older men were having a conversation in front of a coffee shop, their voices carrying in the stillness. The ordinary world, still running. The assault hearing the following week was brief. Daniel did not contest the facts, on advice of counsel. The judge accepted a plea of guilty to fourth-degree assault, a misdemeanor, and sentenced him to 40 hours of community service and 2 years supervised probation. The no-contact order became permanent. 3 months later, the grand jury indicted him on 1 count of forgery in the first degree and 1 count of theft by unlawful, taking over $10,000. He pleaded guilty to the forgery count as part of a negotiated resolution. The theft charge was reduced. He was sentenced to 2 years of supervised probation, ordered to make full restitution to the estate, and required to surrender any remaining claim to the property in exchange for the reduced sentence. The house was sold 6 months later. The proceeds, combined with the restitution payments made in installments, were distributed according to the original will. My attorney handled the closing. I didn't need to be present. I was at my desk in Cincinnati when my phone showed a notification from the title company transaction complete, funds transferred. I looked at it for a moment, then set the phone down and went back to what I'd been doing. My mother sent a card at Christmas. No letter, just a card with a printed sentiment about family and a line in her handwriting that said, "I hope things can be different someday." I read it twice, then filed it with the rest of my documentation from the year. Not from bitterness, just from habit. I filed things. I didn't think about Daniel much. When I did, it wasn't with anger. It was with the same kind of detached analytical curiosity I felt about any failed system. What was the moment it went wrong? What condition allowed it to persist? What would have needed to be different? I'd been the corrective mechanism in this case. That was my function, and I'd performed it. My director promoted me in January. Senior Compliance Officer, Financial Crimes Unit. He shook my hand and said, "I hear you've had quite a year outside the office." He said it carefully, the way people do when they know something but not everything. I said it had been educational. He said, "Good instincts are worth more than any certification. Keep them sharp." I said I intended to. That spring, I went back to Lexington once, alone, just to drive past the house before it changed hands for the last time. It was a Tuesday morning, the neighborhood quiet, the old oak tree in the front yard just starting to come back after winter. There was a lockbox on the door and a real estate sign in the yard. I sat in my car for a few minutes. I didn't feel nostalgic, exactly. I felt factual about it. This was the house where I'd learned to read patterns, where I'd learned that love and fairness weren't the same accounting category, where I'd learned that silence wasn't always submission, sometimes it was just precision, waiting for the right moment to land. I thought about my father in his armchair, the will he'd written carefully, believing it was enough. And maybe it was enough, in the end. Not because the system was perfect, but because I'd known what to do when it needed correcting. I drove back to the highway without looking in the rearview mirror. The case was closed, the records were filed. The money was where my father had intended it to go. And somewhere behind me, in all that quiet, justice had done exactly what it always does when you stop waiting for it to announce itself. It just showed up in the paperwork.